honourable member for Esquimalt, Juan de Fuca.
Well, thank you, Mr. Speaker. I'm proud to stand to speak in the House today on one of the most significant pieces of legislation to come before this House, certainly while I've been a member of Parliament. It is indeed a piece of legislation touching on the two most important topics we ever deal with in this chamber, national security and our civil liberties. I'm proud to speak on Bill C-51 as a member of Parliament for Esquimalt, Juan de Fuca, a riding which plays a key role in our national security as home of CFB Esquimalt and our Pacific Fleet. I'm also proud to speak today as the NDP Public Safety Critic and as a member of the official opposition, a party whose leader has taken a strong and principled stance in opposition to C-51, even when at the outset the bill appeared to be overwhelmingly popular. I remember quite clearly the first scrum on C-51 I faced as NDP Public Safety Critic after we announced our opposition to the bill. Journalists asked me how we could be opposing something that was so popular when 82% of Canadians polled said they supported the bill. My answer to the media that morning was that I believe it's the role of the official opposition to inform public opinion, not to run away from it. It was clear the government intended to marshal the politics of fear to stampede Bill C-51 through the House. We knew this would be an uphill struggle, but I trusted at the time few Canadians knew exactly what was in the bill, and I also trusted that when they did know what was in the bill, they would not likely like what they'd seen. What the poll told us at the time was that Canadians believed that the threats from terrorism are very real, and we all acknowledged that fact. It also told us that Canadians believe the government has a responsibility to do something about those threats. It told us nothing about what was actually in the bill. And I believe, as most Canadians do, that the government's responsibility is to protect both public safety and our fundamental freedoms. Instead, this Conservative government has chosen to risk sacrificing our freedoms for security. What the Conservatives are proposing in Bill C-51 fails on two grounds. Incredibly, it manages at one and the same time to constitute a threat to our basic civil liberties, while also putting forth measures, many of which will be either ineffective or unnecessary. Unfortunately, the government is pressing ahead, refusing to listen to legal experts, civil society organizations, and the tens of thousands of Canadians who have turned out at rallies across the country to express their concerns about C-51. Unfortunately, the Liberal Party wilted almost immediately in the face of the pressure created by the government to stand with them or stand with the terrorists. And we heard yet another example of that this morning from the Minister in his opening remarks. But before Canadians had any chance to find out what was in the bill, the Liberals had already promised to vote for the bill, and to do so, even if the Conservatives refused to amend the parts of the bill that the Liberals said they were concerned about. The Liberals were even heard saying publicly that they did not want to get on the wrong side of public opinion on terrorism. Well, I firmly believe they now find themselves on the wrong side of Canadian public opinion. As the debate on this bill draws to a close, under the 94th use of time allocation by the Conservatives to limit debate, let me review my major concerns about both the ineffectiveness of Bill C-51 and the threats it poses to our civil liberties. In the time I have, I want to focus on four major problems I see in this bill. First, on information sharing. The Conservatives pretend that Bill C-51 corrects problems with sharing information on the use of violence and involvement in terrorist activities. Information sharing within government of a kind with which few would disagree. If someone is involved in terrorism or the use of violence, obviously, government organizations need to be able to share that information. But what C-51 does instead is that it creates sweeping new powers to share information among a vast array of government departments and agencies on almost anything, not just on terrorism and violence. Yes, information sharing on terrorism, but also national security, which is given a new and very broad definition, one which includes threats to Canada's economic stability, threats to Canada's infrastructure, like pipelines, even threats to Canada's diplomatic relations with other countries. And the list goes on for an entire page of legal descriptions of the kind of things which information could be shared upon. And so it's quite easy to see why Canadians are legitimately concerned that there's a significant loss of their privacy contained under the excuse of necessary information sharing about terrorism. The information sharing proposed is so broad that the Privacy Commissioner concluded it would potentially allow the government to create a personal profile on each and every Canadian. Now, we tried to have the Privacy Commissioner appear before the committee. He is an officer of Parliament. He is officially our advisor as parliamentarians on privacy rights. So we put the motion to the committee that he should come so we could discuss his concerns about the bill. And the Conservatives blocked the Privacy Commissioner's appearance at the Public Safety Committee. Conservatives like to insist that legitimate dissent could not possibly be caught in this information sharing. Yet we had a police witness testify in committee that this was exactly his concern. And he also raised the question of the ineffectiveness of collecting too much information about Canadians. The argument is often made, especially in the law enforcement community, that looking for terrorists is like looking for a needle in the haystack, and that the last thing the police need when they're doing this is more hay. And so collecting information about all of us will pile up information so that we risk missing the real threats to our public safety. By the way, the Liberals on this point say the bill can be fixed later after the Conservatives are defeated, but it's important to note that the information sharing part of the bill is not one of the parts they propose to fix. They actually support this broad information sharing, even though it presents a great threat to our civil liberties. The second area of which I have great concern is the granting of new powers to CSIS to disrupt terror threats before they take place. This, I have to say, is also a provision of C-51 supported by the Liberals. Now, these activities of CSIS, first of all, and probably most importantly, would conflict with the existing activities of the RCMP. And the very reason that CSIS was set up was to divide information gathering from the disruption of terrorist threats. So there's a redundancy that's created here that has a great danger, which even Justice Major, who the government likes to cite, acknowledged might create a confusion about who's actually responsible for what when it comes to disrupting terror threats. But what's most disturbing about this is the very broad grant of power to CSIS that's contained. The Bill C-51 specifically says CSIS' new powers would only be limited by prohibiting engagement in murder, sexual assault, and interference with the justice system. This is an amazing grant of power for secret activities in a democratic society and of great concern to all Canadians. Now, the government likes to say, oh, don't worry, that requires a warrant. While these CSIS activities do not always require a warrant, it's left to CSIS to decide if it believes its activities might violate a charter right, then they will apply for a warrant. Now, what's allowed without a warrant? There's a whole range of things that are clearly going to be allowed, and one of the concerns that's been raised by those who work in the internet industry is that it might involve CSIS going online and changing people's posts or deleting their posts, things which would not necessarily violate a charter right, and therefore, in CSIS' mind, wouldn't require any kind of warrant. But the government goes further and says, well, why are you concerned? These warrants are just like the warrants now used by the police. The problem is that they're not at all like the warrants that are used now by the police. Warrants that police seek now in criminal cases are to make sure their activities comply with the charter, not warrants to violate the charter. And what's proposed in this bill is exactly that, that a court, a judge, if you can believe this, would be asked to authorize in advance charter violations. This raises serious questions about the role of the judiciary in our society and very serious questions about the rule of law. The other thing that's different in these warrants is that when police seek a warrant in a criminal case, that warrant ends up back in front of the courts as part of that criminal case. So there is supervision both at the front end and the back end by police when it's a warrant under the criminal code. There's supervision at the front end by a judge and at the back end by a judge when it's a warrant under the criminal code. Neither of those things are true when it comes to these new warrants, which would authorize CSIS to violate the charter. They will be carried out in secret, and a judge will never see what's happened to that warrant should they grant one. Third concern that I want to talk about today is another favorite of the government in this bill, and that's creating a new offense of supporting terrorism in general and recklessly. Now, recklessly is a term that we do find in the criminal code, but supporting terrorism, quote, in general, is not a term we find anywhere in the criminal code. This would create a criminal offense lacking the basic requirements of a normal criminal offense. A criminal offense involves intent plus action. What is the intent involved in supporting terrorism in general? Very difficult to see that there's an intent to do anything. And what is the action? Clearly, there's no action involved here. Therefore, some have concluded that this new offense really amounts to a kind of thought crime, that for your opinions, you might be subject to a criminal prosecution. And it's certainly an offense that would produce a chill on free speech in this country as Canadians try to understand what on earth this new offense means. But it also raises another question about why it's needed. Given the record we have in Canada of successful prosecutions under the existing criminal code, why do we need a new offense that would produce such a chill on free speech? It's simply not been established. And in committee, when I asked the Commissioner of the RCMP, would he have been able to prosecute the perpetrator of the attack here in Ottawa last October, he said very clearly, yes, the existing legislation would have been sufficient to prosecute him. We've had successful prosecutions of the Toronto 18. We have a prosecution going on in British Columbia right now. So clearly, the police don't lack power to pursue those who are actually involved in violence and terrorism. A fourth concern I have is one that runs several places in the bill, and this is about lowering the standard for police action from reasonable grounds to suspicion. And it in particular applies to the idea of preventative detention and recognizance with conditions. So currently, for the police to detain someone, you have to have reasonable grounds. And what that means in common language is you have to have evidence. What the bill proposes is to allow the police to detain someone preventatively on the basis of mere suspicion. And I think that this is another element which is of great concern to many, many Canadians, because we have a disturbing record in Canada on detention in times of crisis. You need only look at the detention of Ukrainians, Germans, and Italians during World War I, or in World War II, the detention of Japanese Canadians, or even in the 1970s in Quebec, the detention of many people under the War Measures Act, some 500 people who were never subsequently charged with any offense, let alone convicted. So many of the concerns we've expressed about this bill involve this apparent conflict with the Charter of Rights and Freedoms. And many witnesses expressed those same concerns. We asked the government to table in the committee the advice it received on the constitutionality of the provisions of Bill C-51. Expressly asked the Minister of Justice. And he used a very strange excuse. He said, these matters, of course, cannot be, this advice cannot be tabled in committee because it violates solicitor-client privilege. And what he did in that is stand solicitor-client privilege on its head. He's not the lawyer, he's the client. And clients can always waive that privilege. And he could have very easily tabled the advice, and it makes one wonder how firm the opinion was of the Department of Justice experts on the constitutionality of Bill C-51. So the Conservatives were very clear on C-51 from the beginning about two things. The first, I would say, is they didn't really want Canadians to know what's in the bill, and second, that they didn't intend to listen to Canadians when they actually talked about what's in the bill. So when I'm alleging they didn't want Canadians to know, how do we know that? Well, they both rushed and limited the debate in this House. And as an important part of democracy, Parliament allows the public to know what the content of bill is by the debate that we engage in this chamber. So the debate was limited at second reading to 3 days. That sounds 3 days. That sounds long. But when you actually look at how Parliament functions, it means the official opposition with 90-some members was limited to 6 speakers on a very important bill. They attempted to limit the witnesses appearing at the Public Safety Committee. What they initially proposed was three meetings and 18 witnesses. Now, I can't, of course, talk about discussions that went on in camera, but at the end of those discussions, we did end up with 8 meetings and 48 witnesses. But that still is less than half of those who wanted to appear before the committee. They also insisted on a very short deadline for those witnesses to appear. And in the end, we ended up having 36 witnesses appearing before the committee in 4 days. 36 witnesses in 4 days. And so if you want the public to be able to follow the debate and understand what witnesses are saying about the bill, then you would not schedule 36 witnesses in 4 days. This schedule also meant that some very important witnesses were not able to appear before the committee because they were given only a very limited choice of dates, 4 days. If they were not available because of personal and other obligations on those days, one very important witness had a medical procedure scheduled. Well, another had professional obligations outside the country. If you were not available during those 4 days, you could not appear as a witness. It was still clear last Thursday when we came to discuss third reading, report stage and third reading debate, that the government was determined not to have a full ability to debate this bill when they introduced time allocation for the 94th time. Now, Conservatives prefer to call this scheduling, but in fact we know what it is. It's closure. So we ended up with only 2 days at report stage and today only for third reading debate on this bill. And I know that many of my colleagues in the NDP caucus who would like to stand in the House and represent their constituents are going to be denied that opportunity because of this limit on the debate. Now, I've also alleged they didn't intend to listen to what Canadians had to say. And let me give some examples of why I believe that to be the case. First, there were limits on the number and the refusal to hear some witnesses. And I've already talked about the government's blocking the Privacy Commissioner from appearing before the committee. There was also the treatment of witnesses before the committee. Some of it was reminiscent of the tapes I've seen from the U.S. McCarthy hearings in the 1950s. Shamefully, government members asked Greenpeace, are you or are you not a threat to national security? And then they were told there was no time for them to answer that question. The first Muslim witness who appeared, the National Council of Canadian Muslims, was accused of being soft on terror. And Amnesty International was accused of supporting terrorist organizations and given no opportunity to reply to that smear on their reputation. And finally, of course, I would cite the fact that all 112 opposition amendments that were put forward were rejected by the government. The only changes in C-51 came when the government adopted 3 of its own very minor and deceptive amendments. On information sharing, they agreed to an amendment which says information will have to be shared according to law. Well, of course it does. That's a meaningless amendment to this bill. They agreed to put in a provision that said there would be no arrest powers for CSIS. Of course, no one ever thought there were arrest powers under the criminal code for CSIS. So we moved a sub-amendment to put a ban on detention by CSIS and rendition, taking people into custody abroad and turning them over to other powers. And the government said, well, there's no intention for CSIS to have detention powers and rendition powers. And so we said, let's vote for this amendment to put it in the bill that CSIS will not have the power to detain Canadians inside or outside Canada and will not have the power to turn Canadians over to foreign governments. And they voted against that amendment. On the no-fly list, which the minister mentioned in his speech, I'll have to say, it's going to be expanded, but it remains just as ineffective and without good appeal processes as it does now. And the amendment that the minister talked about, the airlines appeared and they said they had some problems with the bill. First of all, they hadn't been consulted before it was introduced. And secondly, there was a clause in the bill saying that the minister has the power to order airlines to do anything in order to meet threats to national security. The airlines felt that the power to order them to do anything was just a bit broad. So the government's amendment says now that they can be ordered to do anything that is reasonable in the opinion of the minister. Okay, not much of an amendment. So here we are now under time allocation, just 1 day away from the passage of C-51. It's clear that Conservatives have not been listening, but it's clear that Canadians have been listening. They've seen what's in the bill, and they don't like what they see. But the Conservatives are stubbornly pressing ahead with C-51, despite ongoing opposition from 4 former Prime Ministers, 5 former Supreme Court Justices, almost all witnesses at committee, including their own witnesses, and despite the clear opposition of the vast majority of Canadians. This will leave Canadians opposed to C-51 little choice when it comes to October but to defeat the Conservatives, and while at the same time remembering that electing the Liberals won't help on this one because it's only the NDP that has pledged to repeal this dangerous and ineffective bill. The good news is that 2015 is here, and in a few months Canadians will get a chance to replace the Conservatives with the first national NDP government. So, in conclusion, Mr. Speaker, we believe that Bill C-51 is unfixable in its current form. That's why we moved to delete all of its clauses at report stage and voted against the bill. And it's why I now move seconded by the member for Beaches, East York, that the motion be amended by deleting all the words after the word that and substituting the following. This House declined to give third reading to Bill C-51, an act to enact the Security of Canada Information Sharing Act and the Secure Air Travel Act to amend the Criminal Code and the Canadian Security Intelligence Service Act and the Immigration and Refugee Protection Act, and to make related and consequential amendments to other acts because it, A, threatens our way of life by asking Canadians to choose between their security and their freedoms. B, provides the Canadian Security Intelligence Service with a sweeping new mandate without equally increasing oversight, despite concerns raised by almost every witness who testified before the Standing Committee on Public Safety and National Security, as well as concerns raised by former Liberal Prime Ministers, Ministers of Justice, and Solicitors General. C, it does not include the type of concrete and effective measures that have been proven to work, such as providing support to communities that are struggling to counter radicalization. D, it was not adequately studied by the Standing Committee on Public Safety and National Security, which did not allow the Privacy Commissioner of Canada to appear as a witness or schedule enough meetings to hear from the many other Canadians who requested to appear. B, it was not fully debated in this House of Commons, where discussion was curtailed by time allocation. F, it was condemned by legal experts, civil liberties advocates, privacy commissioners, First Nations leadership, business leaders, for the threats it poses to our rights and freedoms and our economy. And G, it does not include a single amendment proposed by members of the official opposition or the Liberal Party, despite the widespread concern about the bill and the dozens of amendments proposed by witnesses. Thank you, Mr. Speaker. Bravo.